Okay, everybody, I'm going to start with some kind of housekeeping things to try and get us started here, and we'll try and stay on time here. So you guys should all see the PowerPoint right in the middle of your screen, and then you have to suffer with my photo down in the bottom corner, so my apologies, but I'll be down there in the corner. As you can see, there's been some conversations going on the left-hand side of the screen, or you can put your questions in the little box that has a question mark. If you have a question, I'll be happy to answer them as I see them as I go through this. Bear with me, I'm not the most technologically savvy, but I'm doing my best. And the CMCA credits are automatically generated once the webinar is completed, and they'll be sent via email within 48 hours of the webinar. The credits aren't transferable. So if you have that issue or you have any questions, email education@altitude.law or call our office 303-991-2064 if you have any questions about getting your certificates. Okay. So all of you who may not know me, my name's Debra Oppenheimer. I'm an attorney here at Altitude, and I've been here with the firm now going on 16 years. So we'll try and move this along and get you information. The class itself is about, how do you deal with and how do you manage litigation when your associations, in fact, get pulled into litigation. So we're going to kind of look at two kind of circumstances, which is, are you being sued, or are you going to sue someone? And a lot of the things that you're going to be asked to kind of look at with your boards and help guide your boards with are similar in the two circumstances, but they're slightly different just because of how the situation happens. And then last, we're going to try and look at just some tactics to manage litigation. When you have a situation where your HOA is about to be sued, that involves all kinds of things, from risk analysis, cost analysis to your community, whether or not you have the facts to support your case, do you have the witnesses to support your case, do you have the money to actually take the case, are you insured, do you have insurance to defend yourself? And so those kinds of things, we're going to try and walk through those and look at how that happens, and some of the things that'll help you if you are sued or you're thinking about suing someone. So first, let's look at, why are we in litigation? Well, obviously, HOAs get sued all the time. It might be that a vendor is suing you. It might be you are suing a vendor. It might be somebody visited your property and they slipped and fell, and now, they're going to sue you because they were injured on your property. Maybe a child got injured at your playground, or someone got hurt at the pool. There's all kinds of reasons that HOAs get dragged into litigation. It's just part and parcel to running an HOA. They're very, very common. They happen all the time. Obviously, as an HOA that's enforcing your covenants, there's a lot of times where you're going to be the person who's going to initiate the litigation. You're going to have to sue a homeowner that they didn't comply with the covenants, or maybe they didn't pay their bills. That's the normal, probably the most prevalent types of lawsuits for HOAs, is homeowners failing to pay their assessments. Obviously, where we're at right now, you're probably going to get ramping up and seeing a lot of delinquencies. It's unfortunate. One part of the COVID that's going to be awful for HOAs is trying to deal with the failure to pay. But that's something that you're going to have to deal with. Also, but kind of thrown in the mix is you might need to sue a vendor. Maybe you hired somebody to do a job and they didn't do it right. Or, we're seeing a lot of times where you have one HOA next door to another HOA, and there's arguments about whose obligations are there for maintenance in between the two. And so there's all kinds of reasons that HOAs get into litigation. And so from a manager perspective, being sued is something that's going to be a normal thing that you need to be used to. When you're a board member, it's a risk analysis that you need to make with your attorney and with your manager, because it's going to have a lot of facts for you to analyze the circumstance and to know what you're looking at and how best to deal with it. So let's first look at How do you avoid being sued? I mean, as I said, a lot of these lawsuits, there is no avoidance, but there's obviously things that the HOA needs to at least utilize to try and avoid it and or minimize it if in fact it happens. And step one is aware. You need to know what your documents state. You need to look to what property does the HOA own. That takes a review, a very thorough review of your governing documents. You need to look at your plat maps. You need to know what property does the HOA own, what property is it obligated to maintain, what property is it required to insure. And those may all be different. You may be required to insure areas that are different from the areas you're obligated to maintain. That's very common in a townhome. Think about it. In a townhome, the owners own the entire building, but the HOA maintains it and the HOA insures it. So that's by contract, and that contract is your declaration. And so, step one of best protections for your community is really know your documents. Make sure you have a copy of all your plat maps, all your declarations. Work with your attorney and your manager to go to the clerk and recorder's office and look at all those documents. Make sure you have them all. Once you're aware of what properties you have, then look over the property, right? Don't just say, okay, it says here I have this. Go look at the property. Do visual inspections with your manager. Walk the property on a routine basis. Managers, that's something you guys do. Be aware, this fence is starting to look like it's going to fall down. Does that create a hazard? Do you own the sidewalk? Is the sidewalk, is it shifting? Is there some freeze and settlement such that you've now got trip hazards throughout your community? Is it your sidewalk? Is it the city's sidewalk? Who's going to maintain it? Who's going to fix it? That's something that you need to take steps to make sure that you're aware of and that you're looking at. Education. For board members, this provides you protection if you're sued. If you've taken the steps to go and take classes and read up on what's your obligation and how do you best manage it, if you get sued, now you have a better defense to any claims of negligence because you took those steps. You get to say, no, I didn't sit back and do nothing. I read all my documents. I worked with my manager to make sure I had all my documents, and I took education whenever I could, because that shows that you're doing your best for your community, and that helps deflect and defeat negligence claims. Managers, the same thing. Managers that you're going to get added to the lawsuit frequently. You are the point of contact for most homeowners. So when they get mad, they're going to name you. So when you go do education, that again helps deflect and defeat their attacks that you don't know your job and that you're not doing your job. These things come up later down the road when you're sued, but doing them proactively in advance helps you defeat the lawsuit. So it's very important that you stay educated. It's also important that you stay educated to the laws. Guys, we all know the laws change frequently. Kiowa is frequently amended. It's frequently added on. And so keeping yourself educated as to those changes of the law help you prepare and protect your community. So you really want to make sure you stay educated. Last, you want to have good communication. A lot of times you will see lawyers, they're always sending letters, maybe they're sending emails. There's not a lot of phone calls. And the reason being is not only do you have to communicate, but you have to be able to keep track of what you've said, what you've promised. Those letters from the manager to those homeowners, those became the primary evidence in any lawsuit. That's why all of you are required to have those fine schedules and collection policies. And they set forth what letters are going to go out, what the letters have to say, because those letters are the cornerstone. They become the key pieces of evidence when the HOA is suing somebody. And conversely, when you're being sued, you take those letters to show, look, I tried to communicate. I tried to work with the homeowner. I've been working and keeping track of what we've been saying back and forth. And there was no point where you were ignoring those homeowners. And here's the letters to prove it. If you rely upon phone calls when you get into a courtroom, it's a he said, she said. And the same goes true when it's a contractor. You're working with a vendor and the vendor is maintaining the landscaping, and you're telling them, hey, you've got to go fix this. This looks horrible. This is not done according to the contract. We said we wanted it watered however often, and it's brown. You're not watering it, or you're not taking care of it. If you don't have that in a letter, or you don't have that in an email that you can show in court, you can almost guarantee the contractor's going to say, nobody told me there was a problem. If they'd have told me, I'd have fixed it. And of course, that becomes a he said, she said. And if you file the lawsuit, that affects your ability to prove your case. The other thing that you need to make sure is if in fact somebody comes to you and says, oh, something happened, right? And they've been hurt on your community, within your community, you need to start documenting that. That communication that you have with the person who says they were hurt needs to be in writing. It can be an email, it can be a letter, but it needs to be in writing so you can go, you can show the court later, yes, the minute somebody said something to me, we immediately looked into it. If you put yourself in the best kind of circumstance ahead of time, then you'll be ready, if it happens. Okay, so what happens when you're, again, prepping? When you're looking at your declaration, your critical pieces in the declaration that you really want to focus on to make sure that you're fully prepared is the pieces that talk about your responsibility, your obligations, your duties. They're generally called out in specific areas in your declaration, and you want to look at them. You want to make sure that you have everything that you need kind of listed somewhere of what you're supposed to do. And one of those key things that is listed in your declaration is that you carry the required insurance. You want to be careful that you're working with an HOA insurance agent or you're working with your attorney to get the insurance that matches what you're required to have. I have seen multiple lawsuits recently where homeowners got their homeowner's insurance agent to come help them write a policy for the HOA because, well, he gave them a great deal, and so the board member said, let's bring him in, see if he can give the HOA a great deal. And while he might have given you a great deal, he didn't cover all those things that an HOA insurance agent would understand about. Like one of the things that HOAs frequently get sued on is fair housing claims. They're accused of discriminating against a homeowner, not allowing them to have a dog when the homeowner is disabled. Well, when you're looking at stuff like that and you're saying, what kind of insurance should I have? Your insurance needs to make sure it covers not only lawsuits, but claims. So when you're talking about claims, a claim that you violated the fair housing, that claim is not a lawsuit. It's called an administrative agency. It's in front of the Colorado Civil Rights Division. If your insurance policy doesn't cover those types of claims, if that claim is made against you, you're going to have to hire counsel to defend you, but you're not going to have any insurance to cover that cost. And even if you win in front of a Colorado Civil Rights Division agency, there's no fee shifting, meaning you had to pay out an attorney for all of these costs and you don't get it back, even if you win. So making sure you have the right kind of insurance is one of your strongest protections. Recently had a client up in the mountains call me because they didn't cover owner or have D&O coverage, which is geez, I can't even think today. Officers and directors policy, directors and officers, D&O. And that policy protects you board members from when you're sued for supposedly making the wrong decision. If that's what you're sued on and you don't have D&O insurance, all of the claim is going to be paid out from all of your homeowners. So recently there was a group up in the mountains got hit with a lawsuit for violating FHA. They had no insurance and they had to try and settle the case, and the payment came out of the homeowners. And the payment was, I believe last I talked to them, the demand was like $60,000 to $80,000. And so here you had 20 homeowners in this small community and they each had to cover that. So it was a very bad a result and they had no ability to just fight it because they had no insurance to pay an attorney, and the cost of a litigation in federal court would have been over $100,000. So remember that your insurance is one of your best and strongest protections. You want to have your 9 required policies, because not having them can make you liable for a lot of things, and it makes it so that you can't sue. If you don't have a collection policy, if you don't have a covenant enforcement and a fine schedule, you can't go into court and enforce your liens. So you have to have those policies. Make sure you follow those policies. A lot of times you will have collection cases that are not following a collection policy, and what happens is the homeowner sues the HOA. You're going to get sued because you're not following a collection policy and you're not doing the right things. They might file a Fair Debt Collection Practice Act against you, FDCPA, because you're not following the FDCPA laws. Now, most of the times those aren't going to happen to an HOA, but they can. And if you don't understand what the requirements are, you can very easily violate them. So you always want to make sure that you are following your policies. You want to have an ADR policy. An ADR is Alternative Dispute Resolution Policy. And the reason that's necessary is that it says, what are you going to do pre-litigation? It says, are you going to meet with the homeowner? Are you going to agree to mediate? What are you going to do? If you're going to have those kinds of things, then you want to make sure that you follow them, because if you don't follow them, that may result in a suit as well. Okay, so what happens when you're threatened with a lawsuit? We all have those homeowners that we know threaten us all the time, right? I'm going to call my attorney. And we get kind of so that we ignore it. Well, every now and then, the little boy who cried wolf actually does, in fact, see a wolf, and you do, in fact, get sued. So you want to be careful when you get those threats of litigation. Regardless of, the fact it's that same person who always does it, you want to evaluate it every time it happens. So, each time you get someone step up and say, I'm going to file suit, you kind of want to follow a little bit of the same script, right? So board members, managers, if you guys get that threat, you need to reach out and start looking to what resources you have. So easiest circumstance, it's winter, it's in Colorado, and someone calls you and says, oh my God, I slipped and fell and I hurt myself. You need to immediately start working on, well, what happened? Was it in your community? How do you figure that out? Ask the person who called you. Get as much information from the very first person that talks to you and says that this happened as you can get. Try and get them to get all that information immediately to you. As soon as you can get that information, then you want to reach out to your human resources, your other board members, maybe other managers, maybe if you have developers still on the property, your developers, any other owners, any vendors. You want to reach out to all of those people first and try and get the facts. Where did it happen? Can you get somebody out there immediately to take some photos? Can you write down immediately, what's the weather like? Has it snowed recently? Were the sidewalks shoveled? If you had vendors who did the shoveling, call them. Did you guys shovel this morning? What time did you shovel? Were there any icy spots? Was salt put down? Try and get those facts immediately so that you have them, because this person may or may not sue, but you certainly want to make sure that you're ready in case they do, because that might be months and months later, and you just got the call today. Today is when everybody's memories is going to be freshest about what they did. You want to start making notes and keeping track of it, and you want to put it in a place where you can find it. And I'll talk about that later, about organizing your stuff. But when you start getting that threat, you want to keep one consolidated spot with all your information. Look to your technical resources. When I think technical resources, one of the things we have nowadays is lots and lots of people have what's called Ring cameras, or what are the other ones? Nest, I think, is another one. And they take great photos, and they may show the area, and they may show the person slipping and falling. They may show the person was goofing around and trying to slide down the sidewalk and then lost their balance. Or it may show that there's a spot that didn't get shoveled. It may show you that your vendor missed a spot. You need to know that. But the only way you find that out is looking at what you've got. So once you find the spot where the slip and fall probably happened, you're going to go there and you're going to see, does anybody got one of those Ring cameras nearby? And then you're going to go ask them, hey, do you have any, can I see that photo? Is there any way that you can download that? Can you give me that video so I have a copy of it? You want to look to your governing documents. Who owns the sidewalks? Who's responsible to maintain the sidewalk? Was it you, the HOA? Was it the homeowner? Was it the city? Who owns that? But you got to look to your documents. And of course, then you want to know, has anybody ever fallen here before? Have you ever had any prior circumstances where people called and said, hey, this is not being maintained properly? Is there a history of complaints? Because that history of complaints is going to put you in a bad position. So you need to know it now rather than, 6 months down the road when you're sued, because that's something you also want to work with your attorney on. Once you get all these facts, the good, bad, and indifferent, talk to your attorney. And your attorney may say, well, let's turn this over to insurance. Let's get the insurance adjuster out there to touch base with that person and pay the medical bills, because if we stay in touch early on and get things taken care of, we're less likely to have this big suit later. But you got to review that. And the only way you review that is look at the facts, the good facts, the bad facts. You got to know all of them. And if you do it the day you're called, that's when you're going to get the most facts. Obviously, that's not always possible, but you want to do your best, because the sooner you start gathering the facts, the better ability you're going to have to defend later on, whatever that may be. Another circumstance, what about a homeowner who objects to a neighbor's landscaping? He finds out that the neighbor is going to design the backyard in a way that he doesn't like. Maybe he's going to put a playhouse for his kids or a trampoline, and he doesn't like where it's going to go. You need to start pulling your facts together. Who do you call when somebody submits plans? Do your plans require, or does your documents require that they ask for the neighbor's approval? Has anybody ever put one in before? Have you normally told people no? Do you normally tell people yes? You need to start documenting what has the association consistently done on these types of processes, because you want to make sure you know what your documents require. You want to know what you've done in the past. If you have all those things and you start gathering them, the sooner you gather them, the better you're going to be prepared if, again, down the road, this person sues you because they don't like the plans that you have approved. Don't be afraid to do your job. It's very frequent that homeowners try and bully you with threats of suit. It happens frequently. And the most important thing that you want to remember is not to let them scare you away from your job. If your job requires you to send multiple letters to a homeowner who's in violation, don't let them say, if you send me another letter, I'm going to sue you. If your documents require the next letter, send the next letter. You have to be consistent in your application of your policies and your covenants. So don't let them bully you with scare tactics, and just stay consistent and professional. One of the things that you do want to do is, if in fact you've got that homeowner who says he has an attorney, call your attorney. Work with him and say, look, did we mess up? Did we do what the guy's claiming we did? Take a look at your documents, because the sooner you take a look at the documents and work with your attorney to work through and evaluate, the more comfortable you'll be with your decision. Did your decision match what your document said? If you made an error, it's easiest in the beginning to work to fix it. If you don't want to look at it and you don't want to move forward because this guy always threatens that and he never does it, down the road, if he actually does in fact sue you, now you're going to have to back up. We've had circumstances where we've had a community that was for years always sending letters. They never sent them certified. And one homeowner started yelling, hey, these aren't valid because they're not certified. And the HOA said, no, we've always done it this way. This is fine. And they continue down that course. Well, 3 months down the course, and they're ready to sue this homeowner for not paying. And they turn it over to the lawyer, and the lawyer goes, you can't sue. You need to go back in time and send all these letters certified, because your documents say all letters that go out to homeowners must be certified. And so now you've wasted 3 months, trying to get to this point, and you got to go backwards in time, and because in fact your documents did require it. So don't be afraid to call the attorney and ask them to help evaluate, are they correct? Are they wrong? And if you get that lawyer to help you explain it, they send you a letter and say, here's what the documents require. This person who's threatening you with the suit is all wrong. That's not correct. Don't turn that letter over to them, okay? Your attorney's letter is to you. It's privileged. Keep it privileged. If you turn it over to a homeowner, you may waive your privilege. You don't want to do that. If you want to get a letter from your attorney to this homeowner who's threatening, that's fine. Talk to your attorney, have them draft the letter so that it goes straight to the homeowner, but don't take the letter your attorney drafts to the board and just hand that to the homeowner to say, see, you're wrong, our attorney said so, okay? Don't assume just because you make a mistake that you're done for. A lot of times you can just back up and resend the letters and you're just fine. It's something that you need to just kind of work through the process and see what the error is. Sometimes you might have made an error. Maybe your board didn't see something that was built when your statute of limitations came, and then you see it and you want to move forward. You might not be able to. So some errors, they will end the case, but better to know now than before you threaten homeowners with a lawsuit you can't do. And before you spend money on a lawsuit you can't go through with. Don't ever tolerate threats of harm for any reason whatsoever. If anybody says, if you don't do this, I'm going to beat you up, I'm going to do whatever, you're not going to be able to make it home safe tonight, whatever the case may be, don't ever tolerate a threat of harm. Immediately turn that over to the police. Immediately. That is not something that you should ever tolerate. It's not something that's ever going to be acceptable. And it's not something you should ever take on as the HOA. A threat of harm is something that goes to the cops. That's something you want to immediately do. Bullies are awful, and we've certainly seen an escalation of bullies. Don't let them do it. Don't take it. Don't tolerate it. And don't say, next time I'll call the cops. Call the cops the very first time and every time there's ever a threat of harm. Okay, so we're not going to talk now about someone suing you, but whether you should sue. So when you start looking at whether you're going to pursue litigation, understand litigation is always expensive, and you always have to kind of evaluate the process. Many times it's a very low cost because it's nothing more than a collection lawsuit. And those are a simpler evaluation. The evaluation is, have we sent letters? Yes. Has that motivated them to pay the assessments? No. And is the assessment that they haven't paid going to start affecting the association? And generally the answer is yes. Associations rely on people to pay their assessments, and when they don't pay their assessments, the association gets in a point where they can't pay their own bills. Those are necessary lawsuits that you have to file, and if you file them early on, they actually are easier to settle than if you wait until the amounts become large. So when you're looking at evaluating a litigation for collections, is it necessary? Yes. Is it important? Yes. Assessments are the lifeblood of a community. It's how you pay your bills. Positive outcome. That's going to be an evaluation. Did you send the letters the way that you're required to? Did you send the right number of letters that your policy requires? Did you follow all the steps of the collection policy? Is the process manageable? Very much so. A collection is just a very normal process for an association. And then the risk benefit. If you don't go after them and you don't get them to pay, can you continue to pay your bills? And the answer is, for most HOAs, no, you can't. So it becomes a very simple answer to pursue litigation and decide whether or not you should pursue litigation for assessments. The issue becomes a lot more difficult when you start thinking about suing a vendor. Let's say, again, that landscaper. You hired the landscaper to maintain your grounds, and the landscaper is not maintaining them. So now you're going to go through this same process. Is it necessary? Well, what have you done to try and get the landscaper to try and fix his errors? Have you sent him letters? Have you sent him emails? Have you spoken to him? Have you walked the property with him and pointed out the problems? Can you document those things? Because maybe you only made phone calls. So you can't really document in a courtroom that you actually had all these conversations. Those are things that you need to look for to begin with before you start thinking about litigation. Is it important for the community? A lot of community areas are very important to the owners, in that it might give a beautiful curb appeal to your community, and thus it protects your property values. It might be an area that everybody uses for recreation, and without it, there's no place for them to play or their kids to go, maybe to have a picnic, something like that. Is it an important area that you need to maintain? What about the positive outcome? Well, that's going to depend on what the contract says. Did the vendor have a contract provision that said you must do X, Y, and Z, or you can't sue him? Have you done X, Y, and Z? Did you do it exactly like it was said in the contract? If you haven't done those kinds of things, then you've got some issues where maybe you need to step back, do the things in the contract to make sure you've got a good case, and that you can prevail in trial. Is the process manageable? Do you have the witnesses to do it? Do you have all the documents? You're never going to be able to fully control a court, but you can manage the process, and you can make sure that you've got everything to go forward to go after this vendor because they didn't comply with the terms of the contract. What's the risk benefit? That actually on a contract comes down to, is there a fee shift provision in your contracts? When you have a contract signed with a vendor, does that contract say that if you have to sue them, that the prevailing party is going to get their fees back? Because if that provision isn't in your contract with your vendor doesn't comply, well, the work to have it done, if that work is going to cost you $2,000 to go fix their error, but it's going to cost you $15,000 to sue, and there's no fee shift, it's not worth it to sue. While that might not be something you want to hear, that you have to pay somebody else to do what you've already paid for, it's not worth it to file a lawsuit that costs $15,000 that you're never going to get your fees back. There's no benefit to that. So you need to go through this kind of analysis every time you look at suing somebody. And in that circumstance, then, that's how you protect yourself in the community. So what other things should we think about? How many communities, and if you were all in a classroom in front of me, I think I'd get a lot of hands, have those homeowners who are always the problem child, right? They're always yelling at the board. They're always getting into personality disputes with the committees. Nothing's ever right. It's very easy to want to say, look, turn it over to the lawyer or make the lawyer sue them. I don't want to deal with them anymore. It's so costly in time at every board meeting to deal with this. I just want it done. While that sounds like a good answer, we're going to get it out of the boardroom and we're going to get it into the courtroom. It doesn't always work that way. One of the things that frequently happens is those types of personalities push our buttons. And when our buttons get pushed, we don't always follow the course and conduct that we should. And you want to be very careful that on those types of personalities, even more so than anybody else, you dot every I and cross every T. Okay, we're going to go sue them on covenant enforcement. Did we send every letter like the covenant enforcement policy says? Oh, no, we didn't, because they started coming to the board and screaming at the board, and we stopped sending letters. Okay, let's back up. Let's start sending all the letters so that we comply with the covenant enforcement policy before we then turn it over to the lawyer and get rid of them. And yes, it's a headache and it's a hassle, but it's the only way you win in court. And you have to go through that process. Is it in the community's best interest? That's frequently one of those questions that you have to look at when maybe you're looking at suing a vendor or suing somebody that damaged the community. Are you going to be able to get the association's money back? Are you going to get work done in the community that benefits the community? What about, the relationship interest? Okay, for those of you managers, think about it. How many times have you had a board so mad at you or mad at their prior board, they said, can we sue the prior board members? Or sue the prior managers? It happens. People get really emotionally kind of connected, and then when the relationship goes sour, it's kind of like an ugly breakup, and there's a lot of threats going on back and forth. While as a community, you look at your contracts and you say they didn't comply, you have to look at this from a relational standpoint. You had a relationship with that manager. And for the next year or so, there's going to be times when you might have to go back to that manager because they had all of the information about all of the contacts with vendors in your community. And as a board, if you're going to say, I want to sue that prior manager, you're never going to get any more information out of that manager. down the road. That's hard. There are a lot of times that you go from the current manager to the old manager to say, do you remember this case? Do you remember the facts? Did you talk to this person? And if you have sued that management company, you know you can't call them anymore. So you have really cut everything. So you need to make sure that if in fact you're going to file that lawsuit, it's okay that you're no longer going to have any kind of relationship whatsoever with that management company. So make sure that you're aware of that. So what about how the impact of litigation happens on property sales? When you're in a lawsuit with people and you're looking, whether it's collections, it's covenant enforcement, every time there's a property sale, managers are going to get a questionnaire going, are you in litigation with anyone? And if it's a normal common collection activity, it's normal common covenant enforcement activity, you're going to write yes, but only the normal standard covenant enforcement actions, normal standard collection actions, and it probably won't affect the property sales or refinances. They'll go right through. But if you're suing your vendor or your vendor is suing you, that will have an impact on your property sale, because now those lenders who are going to think about putting a mortgage on a new property are going to say, well, what's the likelihood the HOA is going to win? What's the likelihood the HOA is going to lose? How much is this going to affect your financial ability to pay your bills? Those kinds of questions make it very difficult for you to have continuing sales in your community, and they do affect the sales and refinances in the community, because people who are owners who might want to buy into your community, who are really kind of borderline to qualify, those lenders might say, you know what, I don't see the financial stability in the HOA, so I'm not going to finance this. And so those will be sales that you'll lose in the community. So you want to be aware that your litigation will have an effect. If you're sued too often, your insurance rates are going to go up. That's just part of how insurance works, and there's not much you can do about that. So when you look at any kind of litigation, you want to be aware that you're going to have insurance effects, and you're going to have that possibly increased costs going down the road. And then you always want to look to indemnity issues. A lot of contracts with a lot of vendors have indemnity clauses in there. So if there's a lawsuit, you might be indemnifying them. They're very common in a lot of different clauses with a lot of vendors. And so if in fact you get sued or they get sued, the HOA might get joined to that because of that indemnity clause. So you need to make sure that you're looking at any contract and where's the indemnity provisions and how does that work and how's that going to play out in the courtroom, because that's going to affect the lawsuit and ultimately the bottom line of the HOA's finances. When we evaluate a lawsuit, we're going to start looking at, the statutes, the case law. You want to look to, can I enforce this in the courtroom? Somebody asked me as we were getting ready for this class what I thought about the lawsuit that might happen against that Castle Rock restaurant. And then we're going to go as far back as constitutional. Did what happened, was there constitutional issues impacted by some of the things happening around us? And in fact, there's been a lot of things. Right now, we're all looking at, can we prohibit homeowners from going onto our playgrounds? They own property. Oh, that's a constitutional challenge. So there's been a lot of issues that have been coming up that, we've been evaluating, not just state statutes like the norm, but actually going all the way to the Constitution. And that has to happen. You have to be thoroughly apprised of what it is you're looking at when that lawsuit comes in or whether you file that lawsuit. You got to look at your governing documents. Time and time again in lawsuits against HOAs, or if an HOA sues a homeowner, they're filing counterclaims back against the HOA stating the governing documents aren't valid. We have seen more and more challenges to governing documents for the last probably 5 years. And basically what we're seeing is homeowners are becoming more savvy. The attorneys who are fighting HOAs are becoming more savvy. And they're saying, hey, that declaration, it wasn't recorded against the property, correct? And you can't enforce it against me. As we see the homeowners attorneys get more savvy, that means we have to be much more careful before we file a suit, because we need to know, did the declaration actually attach? A very easy example of that is HOAs wants to file a lawsuit because somebody is parking in the street. And the HOA wants to sue them because they just won't stop parking in the street. Well, that takes an evaluation of the declaration. And was the declaration ever recorded against the streets? And frequently the answer is no, it was not. The declarant did a poor job in looking at the documents and the order of the plat maps in the declaration. And while he put things in the declaration saying owners can't park in the streets, he didn't record the declaration against the streets. So you can't go to court on that because it didn't bind the streets. You have to be very careful with circumstances like that. You have to look to the documents. Also, you have to look to the plat map. That's something that's also important when you're evaluating your case. And you want to look to rules and policies. It's become very frequent that I see boards see things that are missed in the declaration, but they don't think they can get the votes to amend, and they want to create a rule to address a deficiency in the declaration. We all need to remember that Kiowa says that your rules and policies cannot contradict the declaration. Well, okay, what about if the declaration is silent? Can I draft a rule about it? Maybe, maybe not. You got to look to your documents. A lot of times your documents might say, and the association can draft rules about parking. Okay, now you've got a little more authority to draft those rules. But if they don't say you can draft rules about it and the declaration's silent about it, creating a rule to try and address a problem, it may not work. It might work for 80% of the time because most homeowners want to comply with the documents, but you're going to have that 20% that's going to push back. And if you didn't have authority to draft the rules, they're not going to stick in court. So when you're thinking of evaluating your lawsuit and can you win or not, you're going to go back to the beginning. You're going to look at a lot of different things that you may have never looked at again. The next thing you got to look at is what facts you got. You got to remember that just because you might have had one homeowner complain to you on the phone, they may be unwilling to put it in writing. They may be unwilling to take the stand. You are going to have a witness that the only way you can get to court is to subpoena them there. And if you do subpoena them there, do you think that they're going to say the same thing on the stand that they told you privately in your office? A lot of times I have neighbors who are concerned with what's going on next door to them, and they want the HOA to fix it and stop it, but they're not willing to put anything in writing, and they don't want to testify about it, and they don't want to do anything about it, which means you have no facts in court. You have no ability because the board member can't go in and say, well, the neighbor called me and said, because that's hearsay. So when you evaluate a lawsuit, you got to get down to, do I have witnesses? Do I have people who are willing to testify to something? Do I have photos of something? Do I have maybe videos of something? And that goes back to what we had talked about on that slip and fall in the beginning. Do you have the videos of the Ring camera showing what happened when the person slipped and fell on the sidewalk? Do you have photos showing that the sidewalk was dry? There was no snow on it. There was no ice on it. Are there any witnesses who saw what was happening besides maybe the person who slipped and fell's friend? You want to know what you've got. You got to evaluate. You got to get into the weeds a bit and start going, what facts do I have to prove the case or disprove the other side's case? A lot of times it comes down to experts, doctors, engineers. Doctors, when it's a slip and fall, what was the injury? What happened? How badly hurt were they? Were they not hurt at all? Are they faking? It might be an engineer to come in and say, hi, this sewer pipe is fine. There's nothing wrong with it. The only reason it was blocked and blocking up into the community was because the person was putting, grease down the sink, and that blocked up the pipes. And that's not anything that any pipe's going to be good for. You're going to get blockages if you have people putting grease down the sink. That's an expert opinion that you have to have, and you have to disclose that early on. And you have to avoid the emotional aspect. Don't let the fact that somebody violated the rules override the fact that you can't win in court. There are a lot of times that we are pretty certain what's happening in a community, and we're pretty certain what's going on. But if we don't have the facts, meaning an actual witness, an actual photo to prove it in court, then we can't win. And the emotional part of letting them go is the wrong answer. It's frustrating, but it's not something that we want to deal with. We have to look at this from the standpoint that we have the case or we don't have the case. And that's the job of a board, is to kind of be that risk analysis. What's the risk that we're going to lose a lawsuit? And if it's a really high risk that we're going to lose a lawsuit, then we need to settle or not take the lawsuit, depending on whether we brought it or it came against us. You always have to look at the other thing that gets attacked is that a lot of times homeowners will attack board members. And they'll say, there has not been an election of board members for 20 years. And that may be the case because you could never get quorum, so you've been appointing to fill the vacancies. And we have seen several courts that have made comments that that's not valid. There's no case law out there that says it's not valid. There's just some courts saying, you know, we really don't like the fact that there's not been an actual election. So if you have one of those communities that you can never get quorum and that you've been going for years by, you know, filling the vacancies by appointment, and now all of a sudden you want to sue, you need to step back and go, what's going to happen? Are they going to challenge this board and say that we're not a valid board? Probably. You need to be aware of that before you file the suit. You know, and, you know, look at it when you go each year to your annual elections and say, you know what, we need to see if we can amend our bylaws. We need to see if we can reduce our quorum so that we can get a quorum, we can have an actual election. Maybe we need to do mail-out ballots. We need to do something. But understand that there are a lot of different things that we see where the board gets challenged, the documents get challenged, and if you don't do an evaluation of all the possible ways you can lose, it'll bite you in trial, and that's not the time you want to have that happen. You know, in real estate, it is about location, location, location. In a lawsuit, it's about fact, fact, facts. What are the facts? We see courtrooms that challenge and want to disallow fines because the verbiage in the violation letters is not matching what the statute says. We see boards that miss holding or offering a notice before, in fact, the fine is imposed. We see an actual hearing held, but the accountant mistakenly puts the wrong date in the ledger, showing that the fine came before the hearing, and so the court disallows it. The facts have to be correct, and small details become very big in a courtroom. When you get those applications in the summertime and you're looking at are we going to approve, are we not going to approve, and you got board members who are busy or they're disconnected or you don't have a DRC and nobody's paying attention, you got to make sure you, the manager, are tracking the timing on those approval letters. Because if your documents say no approval within 30 days, no letter within 30 days, it's deemed approved, you're stuck. You've got to pay attention. You've got to have a tracking mechanism. For communities that have homeowners who want to send everything to the board and nothing to the manager, you got to dissuade them at every step. Send this to the manager. That's how we track things. But understand, the minute the homeowner send it to the board, the clock's ticking. So don't let those things sit in your desk, ignore them, think I'll get to it, I'll get to it. When things come in the door, you need to find a way to put a calendar entry in of the deadline to approve it. Be very careful about your declaration contradicting the rules or vice versa. I have seen many, many times where the board members think the declaration is too strict. Parking restrictions. You can't have an RV in the community ever. So they design and they draft a rule that says, well, you can have the RV in the community for 72 hours to pack it and unpack it. Well, that contradicts the declaration. It's not valid. I get you're trying to be nice, but if your rule violates the declaration, it's not enforceable, and now you've created a problem should there ever be a lawsuit. You want to look at, I've had many, many managers who, when faced with a problem in the community, reach out to an engineer to get some expert advice, which is a wonderful thing to do, and it helps solidify your business judgment decision. But don't forget to get the engineer information in writing. I have seen many a person say a lot of things over the phone, and the minute I pin them down to put it in writing, they back off from about half of it. Well, if you've relied on what they said over the phone, now they've backed it down to half of what they told you over the phone. You're kind of hanging out there without any protection now. So when you reach out to that expert, whether it's an engineer, whether it's a lawyer, whether it is a asphalt guy, to tell you what to do, get it in writing. Because again, it's easy to say one thing, but when you don't back it up and put it in writing, you don't have it in court. Make sure you turn over the lawsuit immediately to insurance. The lawsuit, once it's filed, may have changed, and what they were accusing you of is different than what they actually filed against you. You need to make sure it's turned over. It takes time to get a lawyer appointed. Once the lawyer is appointed, you want to make sure that he has time to answer the lawsuit, to make some decisions, to try and settle it, whatever may happen, but you got to get moving on that quickly. What say you were working to fix something, should you continue working to fix it because a lawsuit's been filed? You got to work with your lawyer on that. There are certain provisions in the law that talk about if you repair something that can't be used against you, but you want to make sure your steps are in concert with your lawyer, because if you stop doing something and he assumes you're continuing, your mixed messages could make the lawsuit very messy. So coordinate everything with the lawyer. Do you remember when I said about making sure you have your documents all in one spot? That's because the minute that lawsuit's filed, you have got to get all of that information to the lawyer. Why? Because he's got a deadline to turn it over to the other side. And if he misses that deadline, he can't use it in trial. It's critical that you get everything to him immediately, and don't put that off, because you can't walk into the courtroom with information, because you've got to turn it over immediately. If it's not turned over, it can't come into the trial. Settlement. Wait a minute, we just sued somebody. Why we're talking settling? We're settling it because mediation is part of every suit. It's something that you always have to consider. You never know which judge you're going to get. You never know what's going to happen. You don't know what law you're going to figure out once all the documents come in on the lawsuit. So we thought we had all the facts. We got their discovery, those documents that they want to use in trial. We just found out we don't have all the law we thought we had, or we don't have all the documents we thought we had. We got problems, or we know that regardless, every judge is going to require mediation. So understand every lawsuit's fluid. Everything changes once all the facts get put on the table, and you need to be willing and ready to discuss settlement, even though you just filed suit. And you always need to think outside the box and try and resolve that. How do you evaluate something? Well, again, you want to be consistent. If every time there's a collection case, you settle it by waiving the fines and interest, always do that. Always know that there's a consistency requirement, because if you treat one homeowner different than another, they're going to raise selective enforcement against you, and that's going to be a problem. Again, that cost-benefit analysis. How much is it going to cost me to get through the lawsuit? What's the ultimate benefit to me? What's the risks that I'm going to lose? What's the risk I don't have the facts? Have they brought in new facts I wasn't aware of? Do I have all the right people that I can take to court? Did the board members change? Did we have an election midstream between when we filed the lawsuit and we're going to get to trial? And I don't have a board member willing to go to trial. The current board doesn't want to deal with this. Those analyses are continually changing as you go through the lawsuit, and you need to work with them and be aware of it, and continue to update your attorney, work with your lawyer, make sure that they know the facts and you know what's going on. How do you, in fact, look at tips to manage the litigation and save money? Know what your ultimate goal is, okay? Is your ultimate goal that you want the community to look great? Did you file suit because somebody's landscaping was awful and they never maintained it, and they just midstream said, look, can I zero-scape all of it? And you know that now down the road, you're no longer going to have to deal with this every summer because they refuse to water their grass. Great, this is fabulous. I've come into mediations where they said, will you drop it if I sue the property? You mean I get them out of the community forever? Fabulous. How do I, where do I sign? That might not have been my goal, but did they offer it at mediation, and all of a sudden we're like, yeah, can you sell it in 3 months? Can you leave? Can we get rid of you? That might be the fabulous fix, because they don't mesh with the community. These are things that you need to understand and be willing to look at. Again, understand that there's all different kinds of strategies to work the case, and they're going to vary on every different case. Making sure you're organized and have all your documents, making sure that you know what your costs are. There's nothing like getting halfway through a lawsuit that you're defending and having the HOA go, we don't have any more money. Now what do we do? So you want to look at all these things and continue on. make sure that in fact you're working on, with your community, working with your board, discussing things and taking care of things. Is what you planned what's still happening? Because if things are going different directions than what's happening, then in fact you need to work at it. Choice of forum. Understand that when you start looking at this, there are a lot of different places you might be able to fix it. Homeowners often ask to talk to the board. The board often says, sure, come meet with me. But then they want to ask to meet with the board again. And they say, no, we already talked to them once. That might not be the best approach. Understand that you either deal with them now, or you may end up dealing with them in a lawsuit. Isn't it better to try and deal with them now? And maybe that does mean multiple meetings with the board, multiple meetings with the ACC. But isn't that better than the choice of having to sue them down the road? The choice between mediation and arbitration might not be one you get to make. That may be in your documents. And so that's something you always have to go to the governing documents. But ultimately, if you can settle it before you ever get to the lawsuit, that's the best forum for the ACC. That's the best forum for the board. Outside of lawsuits is always the best place to settle it. So if you can settle it before someone starts filing that suit, that's the best way to go. The other thing you want to think about on the forum are their timing considerations. Is there a statute of limitations? What's the cost? There are a lot of free mediations out there that can help you, but obviously meeting with your homeowner at the board meeting is completely free. What kind of evidence do we have to worry about? If you're in small claims court, homeowners get to bring any kind of evidence they want, including hearsay. My neighbor told me that the board let the other guy across the street have exactly what they're denying me. That's valid evidence in a small claims court because hearsay is allowed. It's not allowed in county court. It's not allowed in district court. Should you use a receiver? That's a conversation you need to have with the collection attorney. Should you go to foreclosure? Again, a conversation to have with the collection attorney. Can they declare bankruptcy? I don't know. That's an evaluation. But again, you have to look at each of these different things and match them up against the case and then ask the attorney to walk through these. Having these lists is something that only works when you actually have the case in front of you. And then you walk through these and go, oh, okay, let me look each of these items that's in this slide. Can I walk with the attorney and say, should we do this? Should we do that? What's the benefits? What's the cost? Because there's a cost and a benefit to each of these different things. Small claims court costs less because the board can do it, but there's risk. All that hearsay is going to come in. So which is best? And that's an evaluation of each individual case. Be active in this. That means help the attorney gather the facts, help in the planning, and talk about, what's going on as it happens. Don't sit back and just expect somebody else to handle it because you're not going to like what gets handled. You want to ask questions and you want to play a very active role in any lawsuit, whether you're being sued or you're suing someone. And last but not least, understand that, when you're looking at the attorney's fees, when you're being sued, that's why you turn it over to insurance, because that way the attorney's fees are covered by the insurance defense. If you're suing someone, you're fronting attorney's fees, hoping to get them paid back at the end. So you need to understand that's called fee shifting. So, when you're looking at the American rule, fee shifting says that if there's a statute or an agreement that says fees are shifted to the losing party, then the HOA is going to get their money back. But that doesn't always happen. You have to look and make sure it's in your declaration that says there's fee shifting. If you're a Kiowa community, it's part of the statute. But if you're non-Kiowa, it's got to be in your declaration. You have to look to each document, and you need to understand, back to that prior slide, we talked about choosing which courtroom. Most small claims courts won't award fees. Even if you win, they will not. So make sure that, in fact, you have kind of looked through all these different things and understand that even if you win, most judges won't give you 100% of your fees. They'll give you a good portion of them, but they're not going to give you 100%. So when you're trying to sue someone, you need to know that. That's the last slide, but I'm also out of time. But I think I can take questions if you have them. I know that there were questions about getting copies of the slides, and we'll get those to you if you want them. Just shoot us an email. And I'm not seeing any questions. Oh, I see somebody said Ariel's already sent the slide. She is very efficient. She's awesome. So if you guys have any questions, feel free to give us a call, but thank you for joining. It doesn't look like there's anything coming up for questions, so thank you.